Yes.
May it please your Lordship and Ladyship, I appear along with Elliot Gold for the appellant, the Chief Constable of Avon and Somerset Constabulary. My little friends Karen Monaghan, Queen's Counsel, and Christopher Milson appear for the respondent, Nicholas Eckland. And my little friends Anne Studd, Queen's Counsel, and Victoria von Wachter appear for the Independent Office of Police Conduct. Miss von Wachter has asked me to mention that...
Just wait 1 moment, we both shut the doors. Babble coming from outside. Yes.
Miss von Wachter has asked me to mention that the reason she's not wearing a mask is that she has a lung condition. You can see that inhaler.
I think practices vary. People with speaking roles, I think, if they don't want to wear masks, even when they're not speaking, I think that's all right. I don't know whether yes, it's rather bad line of discrimination against those who aren't going to speak, but I think we have to draw the line somewhere. So,
of course,
yeah.
I think I've got to James Berry, acting on behalf of the National Association of Legally Qualified Chairs, and sitting behind him is Mr. Bassett, who's given the witness statement in these proceedings. And the court has got written submissions from Clive Sheldon, Queen's Counsel, on behalf of the National Association of Police and Crime Commissioners. Will, the first order of play is for me to give a full explanation.
Well, you helpfully gave a full explanation in the email which you sent, and I think that makes it unnecessary for you to repeat it here. Apologies certainly accepted, but just so you don't think it was us being tricky for the sake of it. A case like this in particular, where there's a lot of legislation to find your way around, it is not easy, for most of us anyway, just to do that all on screen. You mentioned, and I say this again, not by way of further criticism, but just for the general education, since we have so many members of the bar here, it is increasingly the practice, and I see the reason for it, no problem, for bundles of authorities to be prepared in chambers. But there can be a disconnect because the office sends quite full instructions to solicitors, including the fact there always has to be a hard copy bundle. So your solicitor asking, does there have to be one? Or your counsel asking that. If they got the letter that solicitors had, they would know there always has to be one. And also quite detailed instructions about how to put them together. So if in the various chambers you represent, you're asked to do authorities bundles, can you please make sure that whoever's doing them gets hold of the letter which will have gone to the solicitors? Then that will answer all the queries. Right, enough said about that. Thank you.
Just in terms of housekeeping, other than that bundle, just on that bundle, to help with navigation of it, we've inserted page numbers for the bundle in red in the bottom right-hand corner, which, for anyone who's using the electronic version, match the PDF page numbers. Lord, the core bundle is the next document the court should have, 308 pages, both electronically and physically. That core bundle may include a superseded skeleton argument on behalf of the Director General of the Independent Office of Police Conduct, dated the 27th of August. It may be worth just double checking which version the court has. That version would have been 255 to 264.
Is there any substantial difference?
No, there is. There's a somewhat amended later version that's an additional page.
Okay.
Dated the 3rd of November. Maybe Miss Studd's able to.
Moment. So we're looking
at it up, actually, my lord. It should be on your desk.
Yes, I saw. I just want to know whether it was worth the effort of substituting it. So well, the one that's in there, how do I know whether the one that's in there is the right one?
Because it will be dated August and not redated November, and it won't have my name on it.
So this is an entirely new skeleton?
It's not entirely new. I just amended a little bit at the end.
Right.
That's all.
Is it shown as an amendment, or is it just...
I don't think it is shown as an amendment on your document, I'm afraid, my lord. I'm sorry, because at that point I thought it was just going to go into the bundle.
Yes, I see. No, you're right. We have got the wrong one, so I put that away. But thank you. that's helpful. We also, is only a much more minor thing, but I think the version of the respondent still is an argument, although described in the index as the replacement, that's to say the one that has all the page references in it, wasn't the replacement.
It wasn't, my lord. I apologise for that. I understand it has now been replaced.
It has, exactly. It's been replaced, as it, or merely...
Well, it's either been replaced or my Julia's jumping up, so I shall allow him to.
Yes, my lord.
It hasn't been replaced, but I have the replacement there. Good. Right. Any more housekeeping?
Just sorry, can I just, because I know that Mr. Bassey is then going to stand on his feet for quite a long time. There is also a summary of the Iopc role in complaints and conduct, which I hope will assist you if you have to deal with the differences between the 2012 and 2020.
Well, or indeed, if we have to deal with the position of the Iopc at all, because you're here really to ask us to do something which isn't really before us on the issues on the appeal.
Yes, and I can tell you, my lord, which you will be pleased about, I think I will be maybe 10 minutes.
Right. Well, it would be discourteous for me to say I'm pleased about that. I understand the spirit in which you said that. Yeah.
Well, there's a supplementary bundle, 153 pages. There should also be a chronology from us, which I think is probably separate. It's 4 pages.
Yes, I've got that.
Yes, and perhaps the most helpful part of it is the timeline at the end. Rather helps you in a graphical way to work out when various significant things occurred. So I would commend the use of that document,
right.
That bit of the document.
Yes. Well, mine actually, I'm afraid I hadn't used it. I didn't think I was going to need to use it. That's how it's printed. So if you have got one that prints a bit better, I would be grateful to have one that looks like that.
Yes.
Do it later.
And there are also some additional statutory provisions which the court has been given in a clip, I believe, both of the 2020 conduct regulations and also on behalf of the NALQC by Mr. Berry. Mr. Berry, there's paragraph 3 of Schedule 3 to the Equality Act, which I think he's handed up as well as
yes, I see.
emailing.
Right. Well, okay, we've got all that, and we'll be taking through them when anybody feels they need to.
And finally, in terms of the order of submissions, the proposal from the bar, subject to the court's wishes, is I, followed briefly by Mr. Gold, followed by Miss Studd, and then followed by Mr. Berry before Miss Monaghan.
Oh, well, that wasn't, I must say, what I had expected, because I thought we'd like to hear from Ms. Monaghan, then see what we would need from the interveners. But I haven't discussed it with my lord and my lady. Let's see where we are when you finish.
Well, I'll leave everyone else to decide that.
My lord, do you want me to address that now, or shall I wait until...
Give us 1 minute, max.
1 second, or 10 seconds. It's because otherwise the respondent doesn't get a right to reply to the interveners.
Well, yes, we could deal with that another way, but yeah, okay. Now, anything more before we get to substance?
Just in terms of timings, I hope to resume my seat well in advance of well in advance of the end of the day, with more than sufficient time for my friends, Ms. Studd and Mr. Berry, to make their submissions, and hopefully for
yes.
Ms. Monaghan.
I think it's the view of all 3 of us. That I don't quite know. I can see why this is a case that might have trickled over into a second day, but for it to be a full 2-day appeal, given the fairly narrow nature of the issue, seems to us to be very pessimistic.
Yes.
Right.
I'll take the hint, my lord. Lords, my lady, we appeal with the permission of the Employment Appeal Tribunal. This is a case in which Mr. Eckland, amongst other things, claims that his dismissal for gross misconduct and the process that led up to it constituted disability discrimination. And his claims are broad enough to include it. They're not specifically pleaded, but they're understood to include the way the misconduct hearing was conducted by the panel, by the tribunal, the way that the person
I must
chairing.
say, I hadn't understood that. Where do we understand that from?
Well, it comes from a number of sources, but it emerged at a pre-hearing review for the tribunal that, on inquiry by Mr. Gold, who then represented the employer alone, on inquiry from him of the solicitor to the then claimant, it turned out they were challenging each step of the process, and that's why the preliminary hearing was listed in the way it was. So our understanding is very much that the challenge is to each step, including the way the hearing was conducted and including the outcome.
Are there any pleaded particulars about that?
There aren't, but that's the understanding of the way the case has been put.
Right, well, it may not matter given the issues that we have to decide.
Yes. Maybe the court finds this is a useful test of the sorts of claims that could be brought, and it's certainly been brought widely enough to cover all of those claims.
Yes, I mean, I can't speak, my lord and my lady. I understood the basic case to be that simply that the decision did not take account of the disabilities that led him to do what he accepts that he did.
Yeah.
If there's actually complaints about the conduct of the hearing, that's a very different kind of case. But I take your point. It's a useful thought experiment. Whether or not that's actually the case being advanced, it could be.
Yes.
That's relevant to the point of principle.
Especially in a disability case, of course, because it doesn't need harassment or bad behaviour as such on the part of the panel for there to be disability discrimination. There could be a failure to make adjustments, for example, to account for the needs of Mr. Eckland at the hearing. Indeed, one of the ways we've understood that the case will be advanced if it goes further is to criticise the failure to take account of his condition, which he says amounts to disability, in the way his evidence was evaluated and in the way the case was conducted at the hearing in terms of breaks, etc.
What is evidence before the Crown Court, or is evidence at the...
A mixture, but obviously the evidence in front of the Crown Court, but also his evidence before the disciplinary panel.
That's 37.4 of the grounds of complaint, I think. Claimant relies on giving evidence in proceedings, including but not limited to the misconduct hearing and all the rest of it.
I'm grateful. But as I say, it's very much been put on the basis that it's a wide argument relating to all the stages. Of course, many of them have now slipped out because of the involvement of the Iopc.
Can you just remind us, I probably should have, after identifying that we were not on this appeal concerned with the position of the Iopc, the result of Mr. Milsom's concession below is what? The claim is not proceeding as the Iopc at all?
Yeah. Well, that's right, the claim against the Iopc, well, there has never been a claim against the Iopc.
No, I understand that. The claim relating to the IOPC's acts and omissions.
And whether we're responsible for them.
Yeah, no, I understand
that was conceded eventually not to lie against the Chief Constable.
Thank
you. Mr. Eckland's complaints are also broad enough to include the way that the person chairing the hearing, namely Lieutenant Colonel Stephanie Beasley, the legally qualified chair, took decisions that were reserved to her by the regulations. For example, decisions on which witnesses were permitted to be called, adjournments, questions which were to be asked of witnesses, which were all matters solely for the chair of these hearings. The complaints are broad enough, obviously, to include the finding of gross misconduct, as well as the decision thereafter to dismiss Mr. Eckland. And it might be asked, and perhaps it is rhetorically asked on behalf of the respondent, what's the difference between the many cases in which a former conventional civilian employee who's been dismissed brings a discrimination claim following dismissal by an internal panel and this case? And the answer is almost everything is different about it. And if I can go through each of the aspects fairly briefly, the three main areas of difference. Firstly, police officers themselves are different creatures from civilian employees. Secondly, chief constables and the commissioners of the two London forces are very different creatures from conventional employers, save in respect of their own employment relations in relation to civilian employees of those forces. And thirdly, police officers' misconduct hearings are very different indeed from internal disciplinary hearings conducted by a conventional employer. So turning first to police officers briefly, unlike employees, it's well known that almost every force, in every force, police officers can have no contract of employment. So they have no contract and they have no employment. There are two forces where that's not correct, but they're very much a minority. The main 43 forces in England and Wales are in that category. All police officers hold an ancient office, the office of constable, and their terms and conditions are entirely statutory. And they endure restrictions on their private life and on outside business interests, which are necessitated by the nature of their functions, which are public functions. And they obviously have extraordinary powers over their fellow citizens at all times. A police officer is never not a police officer, and in a sense is never off duty. For example,
or accurately is never not a constable.
That's right.
Is never not a constable.
Apart from if he's suspended, then he's treated not as a constable. But so a police officer therefore can't make a citizen's arrest with the slightly lower standards required for the lawfulness of that, for example. And they can only ever be discharged from the office of constable as is permitted by or under statute. One thing I forgot to mention is, of course, they are human rights public authorities for the purposes of the human rights legislation. And they can be the subject of judicial review in their own names. Conventionally, they're not, but there's nothing that prevents an individual who's been, for example, arrested and wishes to challenge the arrest by way of judicial review, if that's appropriate.
Why judicial review? Would it be judicial review? Wouldn't it be just an ordinary common law claim?
It would generally be an ordinary common law claim, but it might be that you'd wish to seek judicial review in order to obtain an order quickly quashing the consequences of arrest. For example, deletion of the records.
Sorry, I mean, it's dangerous to start going down rabbit holes like that. But this is a general point which is well understood, that police officers are in all sorts of respects different from ordinary employees.
Yes, in almost every respect they're different. But moving on to the Chief Constable, and setting aside for a moment the 1 in 500 officers who are senior officers, that is, above the rank of Chief Superintendent, so putting those officers to one side, the Chief Constable only has one very limited power to dismiss police officers under what was known as the Special Case Procedure, and now under the most recent set of regulations is known as the Accelerated Misconduct Hearings Procedure. Both are still public hearings. They require essentially documentary evidence or witness statements which are sufficient to establish gross misconduct from the balance of probabilities, and that it's in the public interest that the officers cease to be a police officer as quickly as possible. But even in those cases, the Chief Constable could never sack one of her officers on the spot, even if she witnessed a serious offence being committed, disciplinary or otherwise, by that officer. And that's been demonstrated in some recent horrendous cases. The difficulty is that there is always a modest delay at the very least if an officer commits very serious misconduct, including crimes, where there would be a referral to the Iopc, for example, and a need to consult with the Iopc. There'd need to be an investigation report, can be completed quite quickly, and it'd need to be at least 10 days' notice of the hearing. So the chief officer can never dismiss a police officer, regardless of the extreme circumstances, on the spot. So that officer, regardless of the crimes they've committed, they'll no doubt be suspended, but they will be suspended on full pay. And even if they're remanded in custody, they will still be on full pay. The chief officer can do nothing about that. That only changes once they're convicted. So once they're in custody following a conviction, that's the end of their pay. It's only when there's a guilty plea or a conviction for some other reason. So that in my submission shows the stark nature of the limitations on the power as an employer of the chief constable. Now, learned friends have raised the point that for senior officers under the 2012 regime, and we're now for more recent matters in the 2020 police conduct regulations, but under the 2012 regime, for senior officers, the misconduct hearing would make a decision on a recommendation to the chief constable, and then she would decide whether or not to dismiss. And there could be a recommendation to dismiss where the chief constable said, I'm not going to dismiss. And indeed, there could be a recommendation in the opposite direction where the chief constable decided that she was going to dismiss. That's under the 2012 regulations. That's, of course, applicable to a very small proportion of all police officers, being the senior ones above chief superintendent. And even that...
That's the cut-off, is it, chief superintendent?
No, that's right. So senior officers for these purposes are those above chief superintendent. So in the London forces, they're commanders, and in other forces, they're the assistant chief constables.
How many are there roughly?
We think there are 99.8% of all police officers in England and Wales are not above that rank. So roughly 1 in 500 are of that rank or above of commander or assistant chief constable. But even then, the court will hear from me a number of references to the 2020 regime, and that's for a reason, because we say that when one examines the legal archaeology of these provisions, one sees, as archaeologists do, how things change over time. And broadly speaking, how things change over time is a move towards distancing the chief constable from the process. She becomes less and less involved as time goes on, we suggest. That's the direction of travel of the legislation. And when I refer to
Why, nevertheless, that may be true, but the question for us is how far has the process travelled at the time with which we're concerned, which is when the 2012 regulations were introduced?
Well, there are two reasons. First, it may be that the march of change of the legislation tells the court something about the intentions of those making the changes. And second, of course, the court will not want to turn a blind eye to the effects of its judgment in terms of future cases, because it's better, generally, if the set of rules which emerge from a case are durable. It's more difficult if they are not applicable to a regime that is changing. And we suggest that our formulation of the law is durable.
You have to be very careful about that.
Yes.
To decide the dispute in front of you, you try and second guess. In my experience, generally, it doesn't end well.
Well, I take that. I take that. I'll make relatively brief references to the regime 2020 onwards, if I may. It has a limit as to how far it can assist, if at all. I recognise that. And just in terms of explaining when the 2020 regime applies, it applies in relation to allegations which come to the attention of the appropriate authority, in most cases the chief constable, except where the person complained about or the subject of the conduct is the chief constable, in which case it's the local policing body. So it's for allegations coming to the attention of the appropriate authority on or after the 1st of February 2020. So when I refer to the 2020 regime, it's to the sets of regulations and the changes made to other sets of regulations that have applied to allegations that come to light, come to the attention of the chief constable on or after that date. I was about to say that in relation to senior officers, so above the rank of chief superintendent, while the 2012 regime, for those cases still marching through the system, involves the hearing tribunal making a recommendation only and the Chief Constable making the decision. And so if the decision is discriminatory, then it's the Chief Constable clearly who is the obvious discriminator. For the 2020 regime, it's been aligned with the position for less senior officers. In other words, now for all officers, the decision is made by the Misconduct Hearing Tribunal and not by the Chief Constable. And I would also say, just while we're on the topic of the 2020 regime as relates to the senior officers, what's particularly striking about that is that none of the members of the tribunal that hear the misconduct hearing are appointed by the Chief Constable in those cases. All of them are appointed by the local policing body, usually the Police and Crime Commissioner. Two of them are, and the third, forgive me.
I'm afraid this is a sort of detail. We're not talking about the 2020 regime.
Indeed.
Giving us these sorts of nice details about it, I think, will distract us rather than help us focus.
Indeed. The upshot of what I put forward is that for the vast majority of cases, the Chief Constable is in a very different position from that of a conventional employer. Namely, she's the boss who cannot dismiss the vast majority of officers, certainly can't dismiss on the spot, and in the vast majority of cases, doesn't make the decision. And it flows from that she can't dismiss, nor can she not dismiss. She can't block a dismissal. She can't prevent a dismissal. She can argue for leniency in most cases, but can't insist on leniency. And to take Mr. Eckland's example, it's a pretty good example. He gives testimony in the Crown Court which is wrong, said to be false. Supposing the Chief Constable had taken the view that this was caused by disability or was largely a feature of disability, and she wished to make an adjustment in order to take less serious action against him, understanding that this had been caused by the disability that, if she accepted that it existed. In those circumstances, the Iopc would still have the power to insist on the matter being recorded. So they could colloquially call it in. They could then decide to investigate it themselves. And they could then eventually direct the Chief Constable to convene a misconduct hearing. And that arises by a slightly circuitous process, but in essence, the Iopc always has the last word. So initially, in those circumstances, the Chief Constable has to submit a memorandum explaining whether she finds a key case to answer for misconduct or gross misconduct or neither, to the Director General. Director General, if he disagrees, can make a recommendation that there's either misconduct or gross misconduct. And if the Chief Constable disagrees, she submits a memorandum saying otherwise, but ultimately the Director General can make a direction that forces the Chief Constable to treat the matter as gross misconduct and refer it to...
You're just elaborating your point, which we do understand, that, as you succinctly put it, the Chief Constable is the boss who cannot dismiss, and indeed can't make the decision not to dismiss.
Yes.
Yeah, got the point.
And if I can make a very brief reference to the 2020 regulations, so the court knows the direction of travel. In cases like Mr. Eckland, it would be possible for the Director General to present the case. So he would be able to shut the Chief Constable out entirely, save for a very small right to make representations about demotion. But other than that, the Chief Constable could, if the Director General wished, shut the Chief Constable out entirely. That's the current position for more recent allegations. And so if a discriminatory decision is made, or if discriminatory actions are perpetrated by the Misconduct Hearing Tribunal, including a decision to dismiss, including overly harsh findings that are directly discriminatory, etc., or a failure to make adjustments, all of those things, if the Employment Appeal Tribunal is right, then it's the Chief Constable who is liable for that discrimination. And she's liable not vicariously. She doesn't answer for the wrongdoing of another. She's liable effectively constructively. So we've used the phrase constructive liability rather than vicarious liability, because the liability is not based on answering for the wrongdoing of another who is still a wrongdoer, who's also liable. This is being held to be the wrongdoer by being deemed to do the act that they did. And that's the theory by which the employer will be held liable under the Equality Act. And indeed, it's of long standing in the previous discrimination acts and legislation. So the employer is deemed to do the things that his agents do with his approval, with his authority rather, and that his employees do in the course of their employment. One difference that's very important, we suggest, is one exception to that rule is where the employer is deemed to have done the act, or would be, but has taken all reasonable steps to prevent that act from being done, then he escapes liability. But the employee is liable as someone deemed to have aided the employer in doing the unlawful act. That's the way in which the employee is made liable under discrimination legislation. And that's always been the case. So, where one sees...
At what point you're making here, all that is true. Are you saying that isn't so under
yes,
the AT's theory?
Absolutely. That's absolutely right. So, under the EAT's theory and the theory that emerges from the decision in P, the position is because the liability is not based on a direct read across of the provision.
Remind me what section, where's the all reasonable steps defence, just so I can give it a label here.
That's 109.
Is it sub 109?
I'll have to, that should be on the tip of my tongue, and regrettably isn't. I may have a moment to...
All these juniors, someone can tell you.
109.
1094. 1094.
So, no, so your point is no 1094 defence available.
May reflect the fact that it's not always run in every case, but...
I've hardly ever seen it run.
Yes, well, perhaps on appeal not, but it's run from time to time. It's of course unusual. There's a high standard to meet on the part of the employer. Of course, 1094 would still apply in this situation, or it still exists in this situation, but how could it ever apply to the Chief Constable? Because what steps could she take to prevent the discrimination? She's powerless to stop the discrimination. For example, she's utterly powerless to stop a dismissal. And so how could she escape liability on the basis that she'd taken all reasonable steps to prevent the dismissal? For example...
Your position is formally, I wasn't clear about it. I thought you were saying it wasn't even formally available. Are you saying it's formally available but could never be applied in practice, or that it isn't available, isn't even formally available?
Well, I was careless, my lord. It's there. It would be available, but it can never be applicable.
This is all going to turn out to be at the end, but I must have lost you somewhere. I thought you were making a point that the theory on which the EAT found your client liable, which is the theory in P, is something called constructive liability, is different from vicarious liability. Section 1094 applies, but is constructive liability just your label for the whole scheme of the Act, the Equality Act? Yes. I see. So you're not saying it's different from the whole scheme of the Equality Act?
No. I haven't explained myself properly. So if we've got section 109 open in front of us, page 127 of the authorities bundle, it's headed liability of employers and principals. And
sorry, authorities bundle.
tab 7, if there are.
You say page 109.
127.
Yep.
Section 109.
Yep. Oh, sorry, of course.
So, liability of employers and principals. Anything done by a person A in the course of A's employment must be treated as also done by the employer.
Yeah. So when the employee uses racial abuse towards a colleague, that is treated as done by the employer. So that's what you're calling constructive liability. Yes. Well, as you say, that's very standard in the discrimination field. Yep.
It may reflect the fact that discrimination sometimes arises out of a concatenation of circumstances and acts done by different people, which individually wouldn't be wrongful, but all done together.
We don't worry about 2, which is pure agency, or 3, although that's a bit problematic, and then 4 is the all reasonable steps defence. Yeah. And as you say, that's how liability of employers in discrimination cases has always been. Yep. Okay. And so I'm with you now. I may have misunderstood how you're putting it. So that section 109.4 defence is available, but you say that it's a dead letter because of the powerlessness of the employer to override discriminatory things, or the powerlessness of the Chief Constable to override discriminatory things done by the panel. That's the point.
That's right, and it may be worth taking a detour to P. So that's page 460.
Well, if you like, yes, all right. We're going to have to look at P quite carefully.
Yes.
You want to go there now?
If we could, because how they deal with the issue is this way. That's why I said what I did. You look at paragraph 32, that's page 460. The problem is that the disciplinary functions in relation to police officers who completed their period of probation other than senior officers are entrusted under secondary legislation to panels. And the exercise of those functions by a panel is not an act done by either the chief officer or the responsible authority. Nor can the exercise of those functions generally be regarded as something done by an employee of the chief officer or of the responsible authority in the course of employment within the meaning of section 109.1. So,
right.
So what is being said in P is that the panel members are not those for whom the Chief Constable can be deemed to have done their acts. So the root of liability has to be something different. And they go on to say, nor can the panel be regarded as exercising its disciplinary functions as the agent of the Chief Officer. And we agree with those propositions. They're not the employee, none of them, or they're not acting as the employee.
Whether you agree with them or not, you're stuck with them because... Yep.
And so that's right, but the way that the Supreme Court solved the problem and has been upheld, well, which has been said to be applicable to this case under the 2012 regulations, P obviously relating to the 2008 regulations, is set out in paragraph 33. And what they do is, using Marleasing and the purpose approach there, is to read the meaning of section 42.1, which we can go back to, but it's set out there, but with the italicized words added.
Yes.
So the way that the Chief Constable becomes liable for discriminatory acts done at a misconduct hearing, you'll see reference to misconduct meeting, that's for lower levels of misconduct. So in other words, misconduct, not gross misconduct. What they do is to add those words in.
Yes.
To bring the panel into section 42.1.
We are getting, I mean, I'm delighted to look at P. We've got to look at it carefully, but I mean, I thought we were still on your introductory remarks
Yes.
about how different the position of in this sort of case is from the ordinary employer-employee situation.
Yes.
Are we not digressing quite a long way from that?
Not really. I was just trying to be clearer about my point about section 109(4). So the way that the Chief Constable is held liable is reading section 42(1) as it's interpreted following P, and this is if the EAT judgment's right, and then reading section 109(1), because then the Chief Constable is treated as having done the things that the misconduct.
Yes, but doesn't this just bypass the whole of section 109 machinery?
It either formally or effectively does. So it
Doesn't it
bypasses-
formally? Doesn't it? You would not need if in a case that is caught by the ratio P, you would not need section 109 at all, would you?
No, you do.
Or do you? I see.
You do, because the way that the employer becomes liable in any case is under section 109.
Yeah,
Unless he does it himself.
you need section 109 in the case where it is not the employer as such who has done the act. Now, in 999 cases of the company, the employer is a company, and so it'll always be being done by an individual. But suppose you had a one-person employer, running a corner shop, not incorporated. They would be liable under section 39, wouldn't they, without reference to 109 at all.
Yes.
But isn't that what the effect of this is? Suppose the Chief Constable had someone into their room and racially abused them.
Yes.
The Chief Constable will be liable under section 42
Yes.
without reference to 109 at all.
Of course. Of course.
And effectively what's being done here is that you say unusually and unsatisfactorily, but you're stuck with it unless you can distinguish it. The chief officer is being deemed to have done the things which aren't in fact done by him, but are done by the panel. Him or her, I should say. Am I wrong about this? This I thought was the point you were making at the start when I thought you were saying that this was different from the 109 structure, but then you were saying no, it is the 109 structure, but the 109 structure doesn't really help in a case like this. But I don't mind what you're saying. I just want to be clear what it is.
Yes. Well, the way we put it is that section 42(1), as read by P, puts the chief officer automatically in the position of answering for discrimination done by those conducting the misconduct hearing.
Yes, without resort to 109.
Without resort to 109.
Yes, well,
I'm sorry I haven't been clear, but in the normal situation, an employer where the employer hadn't done the thing in question, if they had tried to stop the thing in question, they would say to the tribunal, well, I tried to stop this person doing it. I threatened them with disciplinary action and all the rest of it. I trained them. But the Chief Constable will never, either in practice or indeed in theory, never be able to run that defence. And so she is the only employer who's in the position where she does absolutely everything she can to stop the discrimination in question. And one can formulate all sorts of things that he would have done, including interceding personally, threatening judicial review, which is the only way she could.
I'm saying it's on rather thick. We've got the point.
Yes.
A normal employer could do things.
Yes.
This one can't.
Yes.
Yeah.
And if a normal employer did it, they wouldn't be liable, but the employee would to the victim employee.
Yes.
And that's a very sharp contrast, we say, and that state of affairs can't, in our submission, be right. And we've given an example in paragraph 8 of our
But
first...
hang on, since you've taken us to P, you say it can't be right. It is right under P. You don't like it, you may say they've made a wrong decision, but that is the result of the ratio in P, if isn't the real question for us whether the ratio in P applies in this case.
Well,
You may protest about the unsatisfactory nature of the result as much as you like, but am I not right?
well, I would, in essence, echo the point made by my Lord Justice Coulson that case, P, was about the 2008 regulation.
Well, I just want to be clear about this, Mr. Of course, I did say, if you can distinguish it on the basis that it's a different set of regulations, fine, that's it'd be an important part of your submissions. But under the 2008 regime, all the things that you are now complaining about the 2012 regime on the EAT's application of P would have been so.
All the things I've mentioned so far would have been so in P.
The Chief Constable would have landed up being liable for things done by a panel which he had no power to control.
Yes, that's the effect of P.
That is the effect of P. And so I quite understand why you want to put it up front, why it's unsatisfactory. But if P applies, tough. You try and persuade the Supreme Court to have another look at it.
Yeah.
But so doesn't that really mean that the central issue in this case is whether P does apply and whether it can be distinguished on the basis that the regime has changed since?
Well, that is the central issue. We say...
I might even say the only issue.
Well, how we get there is another question. We say that what wasn't examined in P that was probably applicable in P was that the panel in that case, under the 2008 regulations, was also performing a public function. So
Yeah,
be ahead a little bit in my submission.
since I'm finding this helpful, even if I'm pretty much taking off your course, it just helps us get a framework for where we're going. That's hopeless, isn't it? Because that's effectively saying that the Supreme Court decided it per incuriam. There was a point that could have been taken but wasn't. And we can't say, that the Court of Appeal can't say that the Supreme Court decided a case per incuriam.
No, but what the Court of Appeal can say is the question asked of the Supreme Court was this, and the answer given was that. Now, the question asked of the Supreme Court was not, we have here an officer who could bring a public functions claim under Section 29 against the panel, the Misconduct Hearing Tribunal, in which the judicial proceedings immunity could not be set up as a defence because of the effect of the Framework Directive, because it's a question of occupation and equal treatment in occupation. And therefore, the officer has a right to bring a claim against the discriminators, namely the panel. Now, if they'd been asked that question, then we'd see what the answer was.
Yeah, but you're
They were
framing
not
the
asked
question
that
to suit you. The question was a much more straightforward question. Is the Chief Constable liable for the discriminatory acts or omissions of the panel? That was the question, and they answered it. The reason they answered the way they did, the reason they answered it was that the way they did was that otherwise there would be a breach of EU law.
Yes. Well,
and you're saying, well, they shouldn't have said that because there wouldn't have been, because there would have been another route, namely Section 29(6). But that's a classic point not taken argument or per incuriam argument. If only the Supreme Court had seen that, they wouldn't have thought it necessary to go down this route. That's really what you're saying.
the
If this
position...
point had been argued, they would have given a different answer. No?
Well, they would have, because they had a picture painted to them, which we suggest is either the wrong
Exactly,
picture.
but
In
I'm just trying to see
2008.
what the legal analysis of this is. You are saying that this case was wrongly argued in P, points that were available and which would have led to a different answer weren't taken. That, I've always understood, the legal label for that in a decision which is otherwise binding on us, is that it's per incuriam. I can't think of any other way in which we can get around this. And there is also clear authority that the Court of Appeal can't say a decision of the Supreme Court was per incuriam. We can say one of our own decisions was per incuriam, but not one of the decisions of the Supreme Court.
Well, there are two possibilities. One is it was right to say that to not even raise the prospect of a public functions claim in P. And so the ratio of P in my submission is, it can be boiled down to this simple proposition, that if a police officer is discriminated against in his dismissal, for example, and has no other right of action in relation to that discrimination, will the fact that he is not an employee of the persons discriminating against him stand against his bringing a claim against his chief officer?
So what you said?
So will he have a?
You said P didn't have. Forgive me. P didn't have an alternative remedy because under that regime, Section 29 was not engaged, but now Section 29 is engaged. Is that the point?
Well, our difficulty is that under that regime, Section 29 may well have been engaged. And our position, to be perfectly candid, is to say that it looks like it was engaged at the time of P under the 2008 regulations, although that was never argued, so it was never determined. Yes, but what we say is it's certainly the case now. And what we say is the Court of Appeal can determine today, in this case under the 2012 regulations, as they applied at the time that Mr. Eckland was dealt with, whether or not there was a public functions claim available. If there was, then we never get into the territory of the questions asked in P. In other words, you don't get to a situation that confronted the Supreme Court in P, or indeed the Court of Appeal in P, where there was considerable understandable disquiet that a police officer discriminated against would simply have no right of action, whereas an employee would for a discriminatory dismissal.
Well, there it is. Sorry, we have taken you out of your course, but there comes a point when one needs to know the shape of the argument.
Where it's going, yes.
Right, well, where are you going now?
I was going to the third limb of the differences, and I'll try and be brief. These are points that have been raised in our skeleton arguments. I can do so fairly briefly. The police misconduct hearings, we say, are a completely different creature to internal discipline. And it's been necessary to say that because the written submissions on behalf of the Association of Police and Crime Commissioners suggested that a police misconduct hearing is an internal or private matter akin to an employer's panel considering whether or not an employee has committed gross misconduct. And we say that nothing could be further from that description in relation to these hearings. Firstly, the purpose, well, just as a marker so the court doesn't feel the need to take extensive notes, is in my skeleton argument, paragraph 23, in the core bundle, page 283. We've listed these 16 features. So I don't need to go through them particularly carefully or in great detail, but there are a few where they are controversial, so those may have to be made good.
Sorry, is it page 23 of the bundle or paragraph 23 of the skeleton?
Paragraph 23, page 283 in the core bundle, so CB 283. And the court will see we list over a few pages the differences.
Okay.
So the first difference at the bottom of page 283 is the purpose of police misconduct hearings. They are to maintain public confidence in the police service and to maintain the high standards of the policing profession.
Well, that's true in one sense, obviously, but in another sense, that's secondary. The primary purpose is to see whether or not the police officers should be subject to disciplinary sanctions.
Well, there's good authority, my lord, that the primary purpose is to maintain public confidence and protect the public.
Well, in one sense, that's obviously true. But you only do that by sanctioning officers who've done wrong. So I don't think they're different, but
But an employer conducts disciplinary proceedings generally out of understandable self-interest.
Yes.
It's to protect themselves.
Yes.
Not
Well, there's
the
an
public.
extra element here. But
Yes. Well, there's a fundamentally different element here.
Yep.
That the purpose is to protect the public, maintain public confidence, and to maintain high standards in policing.
Okay.
That is not the general purpose of disciplinary proceedings in the conventional employer. Of course, one can pick out ambulance services, perhaps, where it's closer to this situation, perhaps. But generally, it will be self-interest. In the police, it's the public interest. And there's a wealth of guidance about that given to misconduct panels who hear these cases, who are reminded that the purpose of the sanction is not to punish the officer, because a consequence of that is that mitigation, personal mitigation, is of considerably less weight than it would be in the employment context. Because how sorry one feels for the officer is as nothing as compared to the need to protect the public, to put it in a colloquial way. So the purpose we suggest is very different indeed. The second difference is the discharge of Article 2 or 3 obligations. And this is controversial, and I'll flag it, signpost it, and then I'll leave it for Mr. Gold to make good.
Oh, it's not.
But
This,
we say
this is a quite unnecessary over-elaboration, isn't it? I mean, speaking for myself, sometimes I've got no problem with sometimes it may have an Article 2 aspect to it.
Right.
But the case isn't going to turn on that. Your basic point is that the position of a police officer is different, and therefore the sanctioning of a police officer in a misconduct procedure has all sorts of elements which private employment doesn't. Speaking for myself, I think that's obviously right.
but
But it doesn't get you anywhere.
in my glacial
Does it
way,
get you anywhere?
the destination I have at the end of this glacier is establishing that police misconduct hearings involve the discharge of a public function by those who conduct it, and therefore that Section 29 applies and a claim can be brought under Section 29. And we say there are these differences show that.
If you want to develop, or if you want Mr. Gold to develop this, we would of course let him.
The third aspect is the involvement of the Iopc in the hearing. And I've mentioned under the more recent regulations they can present the hearing, but at the time that applied, both to P and in Mr. Eckland's case, the Iopc, in certain circumstances, which include Mr. Eckland's case, would be entitled to attend the hearing and would be entitled to make submissions through a lawyer. That's a big difference between the private law functions that are undertaken by a disciplinary panel in the average employer. An external person that regulates the police comes in, breathes down the neck of the panel and makes submissions. And they're entitled to attend whether the hearing is held in public or private. Number 4 may be controversial outside of these proceedings, but not among these parties. So my understanding is my little friend, Ms. Monaghan, accepts that Article 6 is engaged.
Well, again, I don't understand why that matters. It matters very much, obviously, if the hearing doesn't respect the Article 6 rights, but that's not what we're talking about here. How does it help you whether Article 6 is engaged or not?
Well, because if Article 8 is engaged, as we say it is, the tribunal making the decision that ends in the determination of the civil right must be an impartial, an independent tribunal established by law. And we say,
but that's what it is anyway, isn't it?
Well, if the court accepts that, I can move on. But we very much say it's an impartial and independent tribunal established by law that determines whether or not to dismiss an officer like Mr. Eckland. Assuming that's accepted, we move on.
Are you comparing this with, say, the average professional tribunal, a doctor, dentist?
No, I'm comparing it with
you're comparing this with the ordinary position.
Yes.
I mean, those are those sorts of tribunals. That's exactly the same.
No, I may again have failed to be clear. I'm comparing it with the the normal employer's internal panel for a disciplinary hearing, because the Association of Police and Crime Commissioners suggested that this is akin to an internal disciplinary hearing that's run up and down the country by all sorts of organisations, local authorities, employers of any sort.
Somehow that's different to a professional body because of the word internal. Is that the point?
No,
It seems to be, if I may say so, it seems rather laborious set of comparisons, setting up something that I'm not sure is in issue.
Well, what seems to be suggested is this misconduct hearing is not any different from a hearing that would take place for any other kind of employee in their workplace.
Well, I think you're setting up an Aunt Sally. I don't think one will say there's no different in any respect. Obviously, it's different.
Or little different.
Well, we'll have to look at Sir to see exactly what she says, but it's different in some ways and not in others.
It's very different, we suggest.
Yeah, of course.
Different to the extent that it's the discharge of a public function.
So can I just be clear where this fits into your argument? So except for a moment, the hypothesis that Article 6 is engaged, and so the hearing has to be impartial and independently fairly carried out. So what in terms of your argument? So that bolsters your Section 29 argument, or
Yes.
right? So it's
Yes.
for the it's to demonstrate the engagement of Section 29.
No, yes, absolutely.
Thank you.
These, we say, build up to a picture. Yes.
Fine.
Yes.
That's what I wanted some help.
But to be clear about that, it's not that if Article 6 is engaged, automatically Section 29 is engaged. It's that it just makes it more likely that it is.
It makes it much more likely.
Okay.
Makes it much more likely. I haven't considered whether it would be automatic.
Can't quite see by what route it would be, but
No, if I can park that if it becomes an issue. But we say these add to the conclusion that these disciplinary proceedings are the exercise of public functions by the tribunal that hear them, by the independent, impartial tribunal that hear them. So I've reached 5 out of 16. I will speed up. It's on page 285. There are misconduct hearings for former officers, and indeed there are misconduct hearings for special constables who are never members of the police force, never employed by them, and indeed for former special constables. And the only reason why there are proceedings for former officers is to discharge the function of deciding whether the individual would have been dismissed for gross misconduct. So in other words, if they're found not guilty of gross misconduct, then the answer is no. Equally, if they're found guilty of gross misconduct, the tribunal has to consider, would we have dismissed this person had he remained a member of the force? If the answer to that question is yes, automatically his or her name is added to the police barred list. And that is we say that, well, it's quite clear that has the legal consequence. He cannot work in or with the police again, at least for 5 years, unless he gets his name off that list after 5 years, the minimum 5-year period. And that's important because there are quite a few cases where the officer will see the way things are going and will resign shortly before the misconduct hearing. It still goes ahead. That is vastly different from what happens in the conventional employer. The employee resigns, there's no hearing. It's over. A police officer resigns, it's not over. The hearing still takes place, and very frequently these hearings occur, the former officer hearings. And to determine that question, it can only have one purpose and one purpose only, or one fundamental purpose, and that is to determine whether the officer should be, in effect, struck off by his name being added to the barred list. And not only are there officers who have been through the disciplinary process who resign before the hearing, there are police officers who have left the force, and it can be for some years. The standard case is for less than a year, but the Iopc can issue a dispensation that permits proceedings to take place where the allegation doesn't come in for a fairly long time. And so the officer is no longer employed in the force, no longer a police officer, and a hearing will still be convened. What is the purpose of that? It is only in order to determine whether the officer would have been dismissed had he been a member of the force. And the only real relevance of that is, well, it vindicates the complaint and all of that. We raised those other points earlier in the list. But it also prevents the officer from doing the same harm elsewhere, and so protects the public and maintains public confidence in the police by making sure he can't join another force under the radar. Number 6, the estoppel point. Again, this is controversial, so I'll invite Mr. Gold briefly to deal with it. But the part that isn't controversial is this, that in a conventional employment, the findings of a disciplinary hearing don't set up a formal estoppel, a cause of action estoppel. But what is controversial is the holding that in police misconduct, for example, the findings, the misconduct process can give rise to a cause of action estoppel. And that's an incident of it being a public function being discharged by an adjudicator. Number 7 in the list, abuse of process. Again, this is not a concept known to internal discipline of conventional employers. But in police discipline, the conventional abuse of process principles arising out of Crown against Maxwell apply. In other words, that a panel will be asked to stay proceedings where a fair trial is impossible, and a panel will be asked to stay proceedings where its sense of justice and propriety are offended by being asked to try the officer, where there's been such misconduct in the way that the officer has been investigated, for example, that it would be entirely wrong for him to face the proceedings at all, whether or not they would be fair and he'd be able to defend himself. Those are concepts unknown to conventional internal employment discipline. And that leads to another incident, and that is that an officer may succeed in such an argument. He may be able to get disciplinary proceedings thrown out, if you like, on that basis, even though there might be some evidence against him, some good evidence. The Chief Constable has no right of appeal within those proceedings. And so from time to time, the Chief Constable will challenge the decision of a misconduct hearing panel. And that, in my submission, is another indicator that the panel is acting in a public function. Because how else do they find themselves in the administrative court arguing a public law challenge to a decision made by the panel?
Sorry, which of your...
we're on 7, which is on page, or just finishing 7, 285. No.
but that's a slightly different point, isn't it, from the one at 7? I understand the point about abuse of process, but
yes.
You're making the point that Chief Constables can sometimes seek judicial review
yes.
of their, as quotes, their own panel.
Well, we of course take strong issue with the...
That's why I said quotes.
Yeah. Oh, yes.
You don't have to miss every point. What's? Can you give us an example of that happening? A case authority for that? I think I was in one myself actually at first instance. Well,
yes.
But there may be others.
Well, I'm hearing a load of murmuring because Mr. Berry and Mr. Gold will have been in numerous of those cases. In fact, I think they were in the same one potentially. But there are numerous cases in which those challenges are made by the Chief Constable of the panel's decision. For example, there was a case. I'll be reminded.
All I want is just for my note is an authority for this proposition.
Can I just turn my back?
Yeah, don't give it to us later. Sorry.
Yes.
Unless you've got it right there. I'm sure it's uncontroversial, but it's not in your skeleton, and I therefore wanted to make a note of it.
Well, we've listed a number in our skeleton.
Well, just tell me which one.
I'm sure I'll have a whisper in my ear in a moment to tell me if I can make progress while I await that. Number 8, public hearings listed in advance. The default position is police misconduct hearings are held in public. That's, of course, entirely different from that of internal private discipline within a private employer. And the allegations must be published in advance. So they're effectively listed, as this case was listed, in a similar sort of way, perhaps with more detail than this case had, setting out what the allegations of misconduct are. The outcome has to be published as well. So you get the listing, the hearings in public, and the outcome is published. And then number 9 is a difference which makes the proposition that these are akin to internal discipline truly extraordinary. Witness summonses are available in the county court or the high court to secure the attendance of a witness at a police misconduct hearing on the basis that they're an inferior tribunal that fall within CPR 34.4. Happens from time to time. It's referred to in the Home Office guidance. I've given the paragraph reference, 1158, the court's note, page 332 of the authorities bundle. And even more extraordinarily, where a person who has been summoned to attend by a court a police misconduct hearing lies or refuses to answer a question at a misconduct hearing after being summoned, they're liable to committal proceedings for contempt of the court that summoned them to that hearing. Entirely different, entirely consistent with our argument that this is public function being discharged by these hearing tribunals. Number 10 strays into 2020 territory, but to make the point that the legally qualified chair in the 2020 regime now has a right to give a direction that prohibits the publication of any matter relating to the proceedings. So that is not applicable to the present case, but is applicable to cases arising after the 1st of February of last year. Number 11, the statutory right to legal representation at the hearing. Again, that is not true of any other internal employer. There may be a contractual right. This is a statutory right to be represented by a lawyer who's entitled to be heard and to ask questions of witnesses and test the evidence. And that's an incident of the Article 6 compliance and the public function being discharged by the panel. Lady, my lords, number 13, number 12, affected third parties must be kept informed. There's a statutory requirement to keep informed in the course of the investigation and throughout the complainant and the interested person whose complaint gave rise to the conduct issue. So those affected by the conduct in question, whether they've complained or not, have a right to be kept updated about the progress of the matter. And indeed, it goes on to number 13, they are required to be notified of the time and date of the misconduct hearing. And they have the right to attend the misconduct hearing with a companion and to put questions to the LQ, to the legally qualified chair, which the chair may or may not put to the witness. They're entitled to put or suggest questions, not entitled to insist on them being asked. And this does happen. Not infrequently, a person will attend who has complained that they were assaulted by a police officer. They'll attend with their solicitor and they'll suggest questions that assist in the preparation of their case against the officer in the civil court, rather like an inquest. It may well be people would seek their costs of attending a disciplinary hearing for that reason. 14thly, a rather smaller point, but perhaps obvious, but the hearing involves an adjudication not of an internal contractual or otherwise disciplinary policy, but a statutory code of conduct about which a body of law has grown up. So they're adjudicating on a statutory code of conduct and the breach thereof. And 15thly, there is a statutory right of appeal to the Police Appeals Tribunal. again, entirely different from the state of affairs in an employer's panel determining disciplinary matters for the employer. And then I think, in fact, my list is, no, forgive me, that gives rise to the potential for a host of different people to seek judicial review of decisions made by a misconduct hearing tribunal. For example, the Chief Constable, as we've indicated, there have been a number of those cases. Officers have sought judicial review of police misconduct tribunals. It's possible for the Iopc to seek judicial review of a decision they're not happy with, or in relation, for example, to the witnesses who may be called or the outcome of the hearing. Potentially a witness, a complainant, the press, or the officer could bring a claim, for example, relating to either the refusal or the acceding to of making the hearing private. So very frequently, submissions are made that the officer's Article 8 rights will be infringed by the allegations being ventilated publicly, or equally that the rights of a complainant or a fellow worker would be infringed by certain allegations coming to light. And if the legally qualified chair, whose decision it is whether the hearing is public, makes a decision that someone is aggrieved by, it is tolerably clear that they can seek judicial review of that decision as a public law error in relation to the weighing up of the balance between the Article 8 and 10 rights of respective interests. So where this takes us is that Article 6 is engaged. The tribunal must be independent and impartial, and one established by law, which it is, and the legislation must be read and given effect to so that it complies with Article 6. And even if the legislation couldn't be so read, it had to be so read after the institution of the police barred list on the 15th of December 2017.
So we're leaving your skeleton argument now, are you?
Lord, yes.
17 is really a conclusion, isn't it, drawn from 1 to 16?
Yes, that's right. That's why I missed it out of my list. So the list is of 16 incidents, and we draw them together in number 17. But the point made in number 17 is that, well, perhaps I can take the court to the provisions we rely on. So if we look at the authorities bundle at page 118, and that should be section 29, I've been referring to the Equality Act. Starts at the bottom of the page, on the previous page, but 118, we rely on number 6, subsection 6. A person must not, in the exercise of a public function, that is not the provision of a service to the public or a section of the public.
Sorry, I'm
so sorry.
The pages.
Lord, it's in the authorities bundle at page 118. It might be behind a tab 7 if there are tabs in it. But
Yeah, there are tabs.
You're rather confusing. There are tabs, but they're misleading. They're not behind the same tabs as they're said to be in the index.
Another apology may be in
But don't worry, pages will get us there.
Yes.
So you were showing us 29.6.
Yes, so one sees it's 29 not on the previous page. So going over the page, it's subsection 6. A person must not, in the exercise of a public function that is not the provision of a service to the public or a section of the public, do anything that constitutes discrimination, harassment, or victimisation.
And that's only a claim for breach is only justiciable in the county court.
That's right. Subject to what we'll say about that in a moment. And we of course rely on subsection 7 as well, the duty to make reasonable adjustments.
Yeah. The exercise of a public function is defined in section 31(4).
Yes.
On the facing page.
Your Lordship, if I read my mind, I was going to take the court to that, and then of course one then considers how that's applied in practice, and it is uncontroversial. But the case is Poplar Housing and Regeneration Community Association Donahue, but it's accepted to be uncontroversial. And I've said it out.
So what is accepted to be uncontroversial?
The point I'm about to make it's probably just easiest just to take the court back to paragraph 17 that your lordship took me to just now, the wrap-up paragraph on page 287 of the core bundle. What's uncontroversial is what we take from the Poplar Housing case, about 4 lines down. The meaning of public function is to be given a generous interpretation and reflects the approach adopted in judicial review. And well, the approach taken in judicial review is that the administrative court will hear challenges to decisions made by police misconduct hearing tribunals. And that is because they are performing a public function and are susceptible to the public law regime and criticism for breaches of public law. We also...
This is very basic stuff, and forgive me. Are you submitting that the test of exercising a public function for the purpose of the Human Rights Act 1998, and therefore for the purpose of the Equality Act, Section 29, is the same as whether or not a decision is judicially reviewable?
It's not the same, but it's very close to it. In other words, if you could seek judicial review, as we say you clearly can, of a decision of a misconduct hearing tribunal that's said to be a breach of Article 10, Article 8, assuming that's right, then it must fall into the definition in Section 31(4) of the Equality Act. It's undoubtedly right, we suggest, that...
so you're saying they are the same test? It must fall in.
Where the challenge is, it relates to a human rights breach, yes. It must be the same test.
Thank you.
It said against you, isn't it, somewhere, that Section 29 is not engaged because Part 3 is not engaged because of the exception in Part 5 relating to work.
Well,
will you be dealing with that at some stage?
Yes, I can deal with it now. That's in Section 28 on the previous page of the, what is it, 117. Section 28(2). This part does not apply to discrimination, harassment or victimisation, but is prohibited by Part 4, Part 5 or Part 6. But the whole problem identified in P was that this discrimination is not prohibited by Part 5.
Right.
Well, it is prohibited by Part 5 as interpreted by the court in P.
Yes, and that's because P relates to a different question, which is if the officer has no right of claim
well, this comes back to
other than the leasing reinterpretation of Section 42.
But the truth is that Section 28 is basically circular. If you're right about P not applying, then Section 29 does.
Yes.
If you're wrong, then they do have a claim under Part 5, in which case they don't have a claim under Part 6.
Yes.
So it really depends on the core arguments.
Well, that's right. And what we say is it's a useful thought experiment to consider the matter without considering P. Just think about the problem presenting itself in this case. It's being suggested that Mr. Eckland has no right of claim. Now, so far that's similar to the situation in P. But the answer is he has got a right of claim. He's got a right of claim under Section 29. And so this court, if it were dealing with the matter afresh in my submission,
Well,
would
you may well be right about
not
that,
end
but
up.
we're not dealing with it afresh.
Well,
I mean,
the court is to an extent because you're looking at a different set of regulations.
Well, that's a separate point.
Yes.
Because that's to say, well, we can distinguish
Yes.
P, and that's an entirely legitimate argument, and obviously you haven't made those submissions yet. But if we can't distinguish P, we come back to the problem that you debated with my lord, that
Yes.
we're not considering it afresh. P arguably deals with the point. I get completely right, of course, that if you can distinguish P because of the changes in the regulations, well, that's a different matter.
Yes, well, it leads to a very unattractive circularity where one ends up looking at Section 28.2 and saying, as my learned friend does, that Section 28.2a bars a public functions claim because of P.
Well,
But
but that's
the
not
logic of
unattractive.
P-
That's just where the authorities are. I mean, it's unattractive from your client's point of view because she gets some landed with the liabilities of the panel that she had nothing to do with, you say. But it's not unattractive from the claimant's point of view because they get a remedy in the Employment Tribunal on a straightforward basis.
Well, perhaps a different thought experiment, which, supposing the issues in P were considered by a court today, and the police argument was that Section 29 applies, you can bring a claim for public functions. Would the answer, would the appropriate answer, or would an answer that worked to that submission be, that's not right, because of Section 28.2? And in my submission, no. So in P, that could not have been set up
Right,
as
but
a
you're
defence.
just feeding back to me the point that it all depends on who's right about P, whether P applies.
Yes, but it must be right in my submission that
Sorry, why in
If
P
the-
could that not have been said? Why in P could that not have been said?
well, if in P the police had argued this is a public function being carried out by the panel and therefore the action should be against the panel under Section 29, what the claimant could not have said in that case is, well, look at Section 28.2. It's barred by the fact that it's covered by work. Because the whole point of P was until you reread Section 42 in a different way because there's no other cause of action, until you do that, it's not prohibited by work. It's only prohibited by work, by Part 5, because there's no other cause of action. And that is the circularity.
Yes. Well,
So in P,
it
this
is-
could not have been run as a defence.
Well, I think we all agree it's circular. Yeah. And therefore, we've got to actually attack the question whether we are bound by P or whether we aren't.
Yes, I do have something to say about that.
I know, and I'm looking forward to hearing it.
Yes. Perhaps I should go straight to it in that case.
Well, sorry, I didn't mean that
No. Well,
in a rude way. But I don't want to. But that's a natural place for you to go next. It's not.
and it's next on my list, in fact, my lord.
Oh, well, there we are. Well, then let's
in fact,
certainly-
Lordship was right to predict that was next to be
Yes.
argued. So, learned friends say that
So what's my heading for this part of your submission?
he and the Commissioner of Police.
Yeah, why P doesn't apply, is that?
Why
I've
he
written
doesn't-
it down as can P be distinguished?
Yes, that's perhaps a better way of putting it.
Well,
Can P be?
You tell us, but
Yeah,
that's what I thought you would say. Yep. Okay.
What's said against us, paragraph 41 of my little friend's skeleton argument, they say that P considered the same issue as arises here. Well, it actually considered completely different issues, and I'll explain why. Firstly, it relates to a different statutory police regime, police misconduct regime, namely the 2008 police conduct regime. The present case relates to the 2012 misconduct regime. Secondly, P relates to a different part.
Are these your trailing point? Professors will ask you about these, but you're just trailing your points, are you? So wait.
Well, no,
Or you're making
I think these are uncontroversial, that
Well,
P
they're
really
not.
was about the 2008.
We understand they're
Yes, of
different
course we understand that. But the point is, are they different in material respects? By material, I mean in respects which affect Lord Reed's reasoning.
Yes, I'm about to
If
come
they're
to
not material, if they are not different in those respects, it doesn't matter that it's a different reason.
Yes. Well, they are different materially. The biggest change or changes are those which we've referred to already, which are the bringing into force of the legislation that required the chair of the panel to be an independent lawyer.
But I'm sorry, Mr. Besley, this always happens when we get into debate. If you're going to come to those submissions, come to them then.
Yes.
But I just, why I intervened at all was I wasn't sure whether you were simply making that submission and moving on, or whether you were telling us that you were going to develop that submission.
I'm going to come back to it in a different way.
Right. So different
go into
regime,
detail.
2008, not 2012. Yes, okay. That's where we stopped.
Different part of the regime, which Mr. Gold will explain, but it relates to, well, perhaps I can trail it this way, that there are two main types of investigation. There are investigations under the police conduct regulations, whether it's 2008, 2012 or 2020, under Part 3 of each of those regulations. So those are, we'll refer to them as PCR regulations. Where, however, the matter is a recordable conduct matter, or it is a complaint made by a member of the public, it is always investigated under Schedule 3 of the Police Reform Act 2002 and the Police Complaints and Misconduct Regulations. And those regulations have various iterations. At the material time, it was the 2012 regulations. At the time of P, it was the 2004 regulations, but they were said not to apply in P. So we say that the scheme that involves investigation under the Police Reform Act and the Police Complaints and Misconduct Regulations is the public scheme. So recordable conduct matters and complaints. And those are the matters broadly which pass through the hands of the Independent Office of Police Conduct. And so those are the matters which are susceptible to the control of the Iopc. And they can take those in, they can investigate them themselves, and they can force the matter to a hearing. They don't have the same powers for matters which are not recordable conduct matters, which are then investigated under the internal regime under Part 3 of the...
Sorry, why are you saying this is different from P?
Because in P, I can take the court.
Well, again, I'm sorry, this is the trouble with trailing submissions. If you're making them, I want to ask you questions about them. If you're trailing them, I'll just write them down and ask you questions when we get to them. I don't want to take you out of your course.
And we can see from P that it was proceedings under the PCR, not the PCMR and all the rest of it. But I think what my lord may be driving at is what are the distinctions material?
Yes.
For the
Well,
reasoning?
well, I think it's paragraph 17 of P on page 456. But what Lord Reed does is that there.
Well, look, sorry. Are we having your submission about this?
Yes.
Now? Okay.
Yes.
Well, then let's go to P para 17. So, what's the submission you're making?
The submission I'm making is that the regime in P was the internal investigation regime under the PCR.
Regime in P was the...
That's explained in paragraph 17.
We haven't got that yet. Okay. So the submission is the regime in P was the internal regime under PCR Part 3,
Yes.
whereas... Because this is why P can be distinguished now.
Yes.
Whereas what?
Whereas in the present case, this was recordable conduct. And I would also say that had there been a complaint in a case, that also takes it out of the PCR regime. Because I think this is not controversial, but in recordable conduct matters and complaints, Part 3 of the PCR is disapplied. So the provisions listed in paragraph 17 of the report in P do not apply in a recordable conduct matter. Now, a complication of P is that when one looks at the facts of the case, and this is illustrative of the overcomplication of the police conduct regime, where people make mistakes, it looks very much as though P actually involved recordable conduct, and so this proceeded the wrong way, but that may not...
That's so general. You know, either take us to P and take us through that point, or don't make it.
No, the point I make is that P relates to the internal investigation system under the PCR.
Yeah, okay, I've written that down. Regime in P was the internal regime under PCR Part 3, whereas the present case, this was recordable conduct. That's correct. Now you're going to show us why that's material.
Well, that's material because the PRA scheme...
I'm so sorry, you were rude me, but you were going to take me to para 17, because you said that was helpful for this point.
Well, I've dealt with it. What occurs is that Lord Reid goes through the internal scheme pretty briefly, but says that it applies.
Yeah,
so he's making clear, because he doesn't say this is not a recordable conduct matter, because perhaps nobody thought of it in P, but he is describing something that is not a complaint and is not a recordable conduct matter.
Is your short point, the material difference is that P did not have a Section 29 claim and Mr. Eckland does. Is that it?
Arguably so. We have the difficulty that when we look at P, we would still say it's a Section 29 claim, in fact.
Yes,
but
I
this is
asked you
different.
earlier to say that you weren't taking that point, that you accept that a Section 29's case could have been advanced in P, but your point was that it wasn't.
I accept it wasn't. I say it could have been, and I say that wherever it takes us is fatal to the use of P as a point of principle in the present case, because it's a point that we say should have been taken. Now,
isn't this, sorry, then what's your answer to my point I made to you earlier, that we are bound by P,
yes,
even if a point should have been taken and wasn't, and would have been successful?
Yes. Well, the answer here is to say that P is different for the reasons I've been saying. So, in other words, that because P concerned the non-recordable conduct regime, the PCR regime, not the PCMR PRA scheme, which goes through the hands of the Director General of the Independent Office for Police Conduct. That is a material difference because...
How is it material?
It's material because the scheme that goes through the hands of the Iopc, whether they choose to take it or not, so they can investigate it, they can direct investigations, or they can let the force investigate it, but they can keep an eye on it and they can change that at any time. So they retain control at all times. That is the public investigation system for police misconduct. It goes through the public body that, if you like, is there to make sure the police, if they're investigating it themselves, as they can do under that regime, don't sweep it under the carpet, so to speak, because it's being supervised in a loose sense by the IOPC.
I got that point, but why is that a material difference?
It's material because you then end up with misconduct proceedings that result from an investigation that's conducted in that way, and that is, we say, even more obviously the exercise of a public function.
Yeah, but we're not on the public function point at the moment, are we?
But well, this goes to the public function aspect. In other words, that.
But what is the? Sorry, I can understand your point. Of course, that actually there was a public function argument available in P, but wasn't taken. It
was a less good public function argument than is available here, is the point in a nutshell. It was available, but we have a stronger argument here because of the stronger public element in recordable conduct, especially where you've got the involvement of the IOPC independently investigating the matter, which gives them particularly strong rights.
It wasn't, you feel constrained to say it was available to P, but it wasn't obvious, and now it's blindingly obvious, and it's a different ballgame.
Well, maybe that's right. And for example, the Iopc had no right to attend the misconduct hearing in P.
The reason why I'm probing why it's really material is if you look at how Lord Reid defined the problem, to which para 33 is the solution. The problem is, he puts at the top of 32, the disciplinary functions in relation to police officers are entrusted under secondary legislation to panels, and the exercise of those functions by a panel is not an act done by either the chief officer or the responsible authority. And then he goes on to make the points about agency and so on. Now, if that is the problem, that's equally the problem whether it is the internal route, the internal regime, under PCR Part 3, or whether it's the recordable conduct stroke complaint regime. They're both entrusted to panels. They both, therefore, create a situation where you can't proceed against the panel because they're not the employer or the quasi-employer. That's what Lord Reid thought the problem was, and that's the solution. Now, that is so whether it is the internal regime or whether it's the recordable conduct regime. Is it not? So your distinction, just to ram it home, your distinction, though a real distinction, which I fully understand, is a distinction without a difference from the point of view of Lord Reid's reasoning.
Well, the last few words of paragraph 32 beg the question that it invites one to ask, what was P about? And what P was about was set out in paragraph 1 of the judgment. As is done in all good judgments, this appeal, this is page 452, concerns the directly effective right of police officers under European law, European Union law, to have the principle of equal treatment applied to them. The question raised is whether the enforcement of that right by means of proceedings in the Employment Tribunal is barred by the principle of judicial immunity, where the alleged discriminatory conduct is that of persons conducting a misconduct hearing. The context, and one sees it in quoted in paragraph 4, is the judgment of Lord Justice Laws in the same case in the Court of Appeal, where he says, however, I've been troubled by a particular feature of this case. If I am right, it would appear that the claims of discriminatory dismissal brought by police officers, where the effective dismissing agent, and perhaps he didn't mean agent in the way that 109 refers to it, is a disciplinary panel such as was convened here, will not be viable in the employment tribunals, yet Parliament has legislated to allow such claims to be made. Although not expressly said, the clear problem being enunciated in P is that unless there is some workaround, some means of establishing liability, the officer who is dismissed by a panel will have no claim against anybody.
Yes, right.
But that's very much what's being said. They didn't say that in terms, but it is very much the problem that presented itself, and that is a breach.
That's entirely what I understand. Yes.
That is a breach of the Framework Directive, and that is what results in the need to read Section 42(1) in a different way in order to comply with the Framework Directive. Now, we say that where that isn't a problem, for whatever reason, this reasoning cannot apply. Now, in the present case, if the court were to accept, because what P doesn't say is, I mean, we said what it does say, and we said what hasn't been argued, but what P doesn't say is a police officer dismissed in these circumstances cannot bring a claim against the misconduct hearing panel. That is nowhere stated either, and that's because nobody thought about it. It appears to be quite clear nobody thought about it before that court. So there's no authority to suggest that an individual aggrieved by the actions of a misconduct panel could not bring a claim arising out of public functions. So when it's raised in a case, and this is the big distinction between P and the present case, nobody ever raised the possibility, it would seem, of a public functions claim against the panel in P. That's the biggest distinction between the present case and P. In the present case, it was pleaded from the first day by Mr. Gold that a public functions test could be, public functions claim could be brought against the panel. This has always been what this case is about, and that on any view cannot be said to be what P is about. You see nothing in P to help you with that question of whether such a claim can be brought. So in my submission, the first question is, can such a claim be brought? If the answer is yes, then one has to consider, does the ratio of P apply in such a claim? And in my submission, the answer is no, it does not. Because the ratio of P applies where the officer is left with no claim against anybody. Even though that's not expressly stated, we can agree that is the implication and the thrust of that judgment. It's to rescue the officer from not having any claim against
again, this is very basic stuff, but if a appellate court proceeds on an assumption that X is the case as a matter of law, and then reaches conclusion Y, is a lower court prepared to say, well, they shouldn't have made that assumption, and therefore it isn't ratio? My understanding is that the lower court can't say that. It can say, well, the assumption was false, but it was clearly part of their reasoning. It was essential to their reasoning. I mean, your whole point is it was essential to their reasoning. But it was nevertheless false because nobody had pointed out there was another route. I mean, what it really, now I understand, I think I've always understood your point, now you articulated it more fully, it really becomes clear this is a point about how you analyse the ratio of a higher court. Well, is not the way I put it to you right? Or can you suggest I'm misunderstanding?
If that proposition were right, then the answer to it is right. But we agree with Mr. Justice Kerr. He indicated that a leapfrog application, if I can use that term, was used, but was sought by both parties in this case.
I saw, yes.
No disrespect for this court, of course. And he disputed the suggestion that he had been bound by P. And we say he was right to say he wasn't bound by P. That's the first point, perhaps more of a jury point. But taking your Lordship's point, what the Supreme Court didn't do is perform any evaluation of the question whether a public functions claim could be brought against that panel.
Hang on one second.
In a slightly different context, paragraph 29 of the judgment, again, just enforces that the court was proceeding on the basis the only remedy was a right of appeal to the Police Appeal Tribunal, so it's implicit in that.
Media, that's absolutely right, and this case is relied on as extolling the no doubt great virtues of the Specialist Employment Tribunal, as is Misconduct, which I won't take the court to, but my learned friend will. But in fact, this case is a comparison between the Police Appeals Tribunal, which has a very limited function. It's got 3 particular grounds it can overturn a decision of a misconduct hearing panel. So it's got a very limited function. It can't award damages, for example.
Yeah, everyone accepts that it's not
obvious.
equivalent or effective.
Yes.
So I think
The point of Misconduct was that judicial review is not in the nature of an appeal, and when one does a comparison between judicial review and employment tribunal, it's clearly a very different animal. So the reference to a specialist tribunal was understandable, but it can't be said, as my learned friends do, that the county court is not a specialist discrimination tribunal, because it is. It and it alone has jurisdiction over the vast majority of non-employment tribunal claims where the judge sits with assessors. And it's only in judicial review, typically, where the High Court has any jurisdiction over discrimination questions, if they arise. So the case was clearly about that comparison. There's no comparison here between, for example, the ability to bring a county court claim against the...
Yeah, but that didn't arise on the way the case was put.
Yes, yes.
So what I'm really pushing away at you is, you can tell it's the point that's worrying me. You know? I have approached this on the basis that if it was essential to the reasoning of the Supreme Court that there was no other route except for the route they took in order to give them a right in the Employment Tribunal, then that's part of their ratio. And it doesn't help you to say, well, it shouldn't have been part of their ratio because it was only an assumption. Nobody argued the possibility of a Section 29(6) route. And I don't quite know what your answer. Your answer is, well, the fact that there was no evaluation, no one argues it, means it isn't part of their ratio. Is that it?
Well, that's right. There's no evaluation. There's no judgment about that. There's no question and no answer. The Supreme Court not asked.
I'm sure there's some law about this, about the circumstances in which an assumption, which is essential to the reasoning, constitutes ratio. Anyway, everyone can look at that.
Yes, I'm sure the message has been received.
So it comes down to this then, because it's relatively straightforward, isn't it? The first question is, you say, just looked at in isolation, can a claim against the panel be brought? And then you say, secondly, if the answer to the question is yes, then does the ratio in P make any difference? And you say no, because you say it wasn't considered. It wasn't a question that was the subject of their evaluation.
Well, I go one step further. I say the question in P is where an officer has no other claim.
No, the question in P is, given that this officer has no other claim, must it be vindicated by rewriting Section 42?
Well, my Lord, happy with that. This officer does have he's time limited now, but he did have another claim.
No, but
so it's different.
The Supreme Court proceeded on the basis that he didn't.
Well, they proceeded on the basis that P, where the panel was differently constituted. We haven't quite got to that yet, but I'm sure the court's aware. In our skeleton, we've explained that the panel.
But all those points don't matter, do they? They don't matter tuppence from the point of view of the problem identified by Lord Reid at Section 32. It's the problem that it's been entrusted under secondary legislation to panels. It doesn't matter whether the panel is of this kind or that kind.
Well, but the theory of my Lord's question is, in effect, does P decide that an individual in her circumstances cannot bring a public functions claim against the panel? And if it does, I say, well, it doesn't decide whether the person in Mr. Eckland's position can bring a claim, because one has to look in either case at the composition of the panel, the way it works, its function.
But why? Why does one have to look at those things?
Because that will tell you whether the panel is performing a public function.
Oh, I see. It comes back to that point.
Yes. And at best,
we keep on coming back really only to that point.
Yes, well, let's suppose that, as a thought experiment, that Lord Reid had said, it's been suggested there's a public function test. I can tell you it's fairly shortly. It's a commander in the force who chairs the hearing, and he's a commander in the Metropolitan Police. He's not performing a public function. The consequences are not career-ending for P because she can still go and work for another police force, albeit it's maybe difficult to find another job, and she may be on intelligence systems that make that in practice very difficult indeed. So on balance, we decided it can't be a public functions claim. Therefore, unless we do something about Section 42, he has no claim at all. Now, assuming that had been the reasoning in P, we would attack that reasoning on this basis, that the panel here is very different, and it has a very different function and a very different consequence, none of which occurred or were the case in P. And one can see that from the timeline that Mr. Gold has prepared, that the main developments, the public hearing, the switching of the commander chairing i.e. a police officer chairing the hearing with a legally qualified chair, and the institution of the barred list as an automatic consequence, your name goes on the barred list, which didn't happen in the case of P. Those three factors alone, in my submission, would be enough to say, well, this case is sufficiently different that the logic in P for rejecting the public function claim doesn't apply. So we can't be in a worse position because of the lack of any argument or evaluation of a public functions claim in P than we could be by trying to reconstruct the best that such an argument could be. And the best it could be is, in my submission, along the lines of what I put forward, the composition of the panel and its consequences and its functions.
So these aren't points of distinction, they're points that you rely on to say that we shouldn't feel bound by P because it wasn't dealing with the same question.
That's right. It certainly wasn't dealing with the same question.
Isn't perhaps logically the right approach to it to decide whether, as you helpfully just put it, do the thought experiment? Suppose Lord Reed had expressly considered whether the panel under the 2008 regime was performing a public function and had decided it wasn't. Whether the changes between 2008 and 2012 would lead to a different answer. If we decide that they would, then I take your point that you can't be worse off because he didn't look at it at all. If we decide that it wouldn't have made any difference, because there's no essential difference as regards public function between 2008 and 2012, then you ask, are we then bound by P because it was part of their ratio that there was no alternative? Not putting it quite right, but I think the first question is to identify whether the differences between the 2008 and 2012 regimes are such as to change it from being not being a public function into being a public function. We see what your case is about that.
The worst it can be for my client is that position, namely that P can be taken to decide positively that the sort of panels that we can reconstruct, in fact are described in P, are not panels which can be sued in their own right as performing a public function. That's the worst case scenario for us, and we have to distinguish, or we have to argue that that may be right, but these panels are sufficiently different and public to amount to panels which can be sued in the county court. And if that's right, that entirely destroys the reasoning of, or that's one way of putting it, but it entirely removes the need to go down the Marleasing route with Section 42, with all the problems that it clearly has in relation to the effects of that in these circumstances. So that's the worst case scenario for us. But we would say that the appropriate course is not to effectively perform a subtraction, so looking at what panels are today and seeing whether that's sufficiently more public than in the day of P to see whether a public functions claim to be brought. In our submission, because the panels are different, this court can simply look at whether these panels are such as to be susceptible to a public functions claim. And you don't have to worry about whether in P the different panels were not susceptible. Because they are, it'd be different, of course, if there was no difference between the two panels and no difference in the composition or consequences. But there's
just look at the facts of this case. Look at the facts of this
Yes.
case.
No, yes.
Let's see whether they're covered by P, and you
Yes.
say no, they're not.
Of course, I'd be in difficulty if the panel here was simply window dressing and a few of the names were changed for some of the titles of people in the panel, but nothing, and a few procedures changed, but nothing of substance. Of course, I'd be in difficulty with this point, but we say they're sufficiently different, plainly so, chaired by an outside person. That's a vast difference with the consequences I've explained, public hearing and the barring consequences. Those are three very big differences which make these panels of a completely different character. Now, it'd be different, of course, if there'd been some sort of evaluation of that in P, but there's a glancing reference to the fact that it's changed, with no evaluation of whether the change has changed anything, has affected any difference.
I understand the submission about the legally qualified chair, and I understand the submission about the hearing in public. Just tell me, with the debarring list, under the 08 regulations, if the panel recommended or decided on dismissal for gross misconduct, there wasn't a debarring list.
No.
Now there is.
No.
Isn't that just improving the remedy? Isn't that just ensuring that a police officer who has been dismissed for gross misconduct doesn't somehow get another job as a police officer somewhere else?
Well,
why does that? I can't at the moment follow why that makes any difference at all. It's just an improvement in remedy.
Well, it's more than simply an improvement, an undoubted improvement in the situation, because of the famous cases in which people did get re-employed from time to time and then further misconduct themselves. But it's more than that.
It was a good thing generally that was improved. But why does that make a difference in this, in the point we're now on, which is trying to say that P doesn't apply? Why does that make a difference?
Well, because I was about halfway through the glacier when I explained the Article 6 engagement. So what has happened?
It comes a step back, and it comes in Article 6.
Yes.
Part of that, but it doesn't go beyond Article 6 for public functions, my Lord
No,
identifies.
it does, because the consequence of this being a determination of the officer's civil rights or obligations is that one has to look at this panel as constituted as being an independent and impartial tribunal established by law. That's Section 3 of the Human Rights Act. So you have to interpret this legislation.
In what sense is it not an independent and impartial tribunal established by law, irrespective of Article 6?
Well, this one, well...
It's independent.
Yes. Well...
Yes.
Well, I'm happy with that.
And it's impartial.
I'm happy with that, because...
And it's established by the 2008 regs.
Yes. Well,
so what do you add by saying, therefore, it's covered by Article 6?
Well, that could be... That would be more difficult to say about the panels in the 2008 regulations that applied to P, because in the 2008 regulations, it was chaired by a police officer, and the other member...
But his whole job was to be independent, wasn't it?
Well,
it was. If in 2008 someone had come along and said, I don't have to be independent of the Chief Constable, they would have been laughed out of court. The whole point of having a panel is that you are independent.
To an extent, but they were not formally independent, because the senior officer would be the chair, he'd be a commander, and there'd be a second police...
Formally independent?
Well, how can
They could get away with it. I mean, just because the regulations have been improved doesn't mean, surely, that effectively we can disregard P and assume that Lord Reed had in mind slightly dodgy tribunals where maybe the police officers weren't independent.
Well,
panels were intended to be independent.
Well, no, they were, but they weren't made formally independent. So they were constituted by a commander, a human resources manager, so 2 police people and 1 lay member. And a significant change is today, and indeed at the time of Mr. Eckland's disciplinary hearing, they were chaired by the independent legally qualified person and had the same independent member and one police person. So in other words, you've gone down from 2 police people out of 3, a majority, which is significant. As in this court, it's a majority decision if there's any dissent. Down from 2 out of 3 to 1 out of 3 is a police person. That must change the degree of independence. There may have been a degree of independence, but following the engagement of Article 6, there is legal independence mandated by the Human Rights Act and the way one reads this legislation. So they are legally independent. And the effect of that is...
Independence is capable of being graded in that way. Something is either independent or it isn't. A tribunal is either independent or it's not. It's not a bit independent, or quite a lot independent.
Well,
anyway, you say that they weren't formally independent because 2 of the 3 were police people, as you put it.
yes, they're police people, not necessarily having to be from the same force, but in practice very often being. In the present case, one has 1 police person, a superintendent. Now, he would today have an absolute defence to any, if he was given an instruction to be harsher, he'd have an absolute defence being able to say, well, I'm part of an Article 6 compliant tribunal and I can reject that order to be more harsh in future. Query whether that's the case in relation to the 2 police people in the 2008 regime. So I would disagree that they're formally independent. They're intended to be independent, but they are 2 police people out of 3. They're the majority. And at any rate, at its minimum, my point is that is a difference, and a big difference between the 2, which enables this court to look afresh at the status and the functions being performed by the Eckland tribunal, if you like, as opposed to the P tribunal.
Okay, and now we're under the heading, can P be distinguished? And really what we've been exploring very helpfully is whether they can be distinguished because the formal characteristics of the panels under the 2002 regime are different, significantly different, you say, from those under the 2008 regime. And you say, really, that is enough, simply to say, put P to one side. The reason why they're enough to put P to one side is that it means that they may be a public body in a way which they at least arguably weren't. Sorry, the public body is not quite the right phrase, but I'll use that. In a way they at least arguably weren't in 2008. As soon as that's established, you're basically free of P. Is that right? Because,
yes, because
sorry, just to spell it out, because there was another route, namely Section 29.
Yes, because the logic of P doesn't apply. If I could take the court to the rationale behind the changes that followed P, it's if we look at page 235 of the authorities bundle, one sees the explanatory memorandum to both the police conduct amendment regulations and the police appeals tribunal's amendment rules. They explain, if one looks at page 240, the reasoning behind having a legally qualified chair. So it's paragraph 7.14 or 7.14. The department considers the introduction of legally qualified chairs to be necessary to ensure, bullet point 1, a greater degree of independence in the decision-making of panels, ensuring fairness for officers, police forces, and any victims or complainants. So that's the first justification given for legally qualified chairs. And
sorry, it's my fault. I just haven't got the reference.
No, maybe it's page 240 of the authorities bundle.
Thank you.
The apologies bundle. So that's paragraph 7.14. So the intent of the Secretary of State was to increase the level of independence, or the degree of independence in the decision-making, by installing a legally qualified chair in place of one of the two police people on the panel. So, to perform another thought experiment, if one had asked the Secretary of State, is there really no material difference between these panels that you're creating with this legislation and the 2008 panels, or the pre-amendment panels? She would have said, of course there's a difference. There's a greater degree of independence, as well as other points that are listed there.
But sorry, always trying to fit this into the overall picture. And the significance of that is that it makes the argument that there is a claim under Section 29 stronger.
Yes. Yeah. And it also makes the argument that there's a difference between the panels which might be taken, or which the Supreme Court might be taken to have said we're not susceptible to such a claim, and the panels that are in existence at the time of Mr. Eckland.
But surely that's only by the... Is that a separate argument from the Section 29 argument?
Well, they're wrapped up together. The question is whether the court can go behind the assumed conclusion of the assumed wordless conclusion of the Supreme Court in P. That,
yes, I understand that, but the only reason we can go behind it is because the assumption can be shown to have been no longer applicable.
Yes.
The assumption is that there isn't another route.
Yes.
The reason why you say the assumption is no longer applicable is that there is clearly now, as there apparently wasn't then, another route. So it is all the Section 29 point ultimately.
Yes, yes.
Right, okay. That's what I thought. Well, there may be more you want to say, but I think, speaking myself, probably to my lord and my lady, may want to say, we've explored that point sufficiently. Yes. Any more you want to add about it?
Oh, but there's just one point I didn't mention, which I ought to have done. It's a less strong point, but it's a less fundamental point. But P predates, but Mr. Eckland's case does not. So Mr. Eckland's case postdates the extension of the misconduct regime and the powers of the panel to deal with former officers and former special constables.
How is that logically relevant? Well,
Because it changes
he's not
the
a
function.
former officer.
No, that's right, but that shows
the
that
public function.
it does. It strengthens the public function.
I suppose so, yes. But I mean, I think a pure logician would say it may be exercising a public function
on those occasions.
on those occasions and not on this.
Well, then the dividing line would be very difficult, my lord, because it's perfectly possible to have, let's say Mr. Eckland, he turns up on day one of his disciplinary misconduct hearing, remaining in the force, sees which way the wind's blowing, resigns that evening, turns up on day two as a former officer. The hearing will continue. So there'd be a seamless transition because the panel is the same and is performing the same functions on the Monday and the Tuesday.
How would that be problematic? The question would then be that if he then says that, make it as easy as possible, that during the hearing they showed that they were discriminating against me on the grounds of whatever protected characteristic it was, you would have a different remedy on Monday than what you had on Tuesday, Wednesday and Thursday. Is that it?
No, my point is the precise reverse, that you'd have the same remedy on Monday and Tuesday. But
yes, I know, but your point is that if the other side were right, there would be a different remedy on different days of the week.
Well, no, because in P, what would happen if she resigned is that the hearing would have no further function. In P, that particularly if she'd resigned before the hearing, the panel would have no function. In fact, in those days, what would happen is she would be suspended to prevent her resigning if that were the intention of the force. Depending on the time period, the law changed a couple of times to prevent people from leaving the force. So whereas the panels in those days had the function of dealing with current officers, and you had to keep people as current officers to prevent them resigning to avoid the consequences of police discipline. Now that function, that feature is gone, but the panel has an extended function, reflecting its greater public functions in the time of Mr. Eckland as opposed to the time of P.
Okay, well, that was the other point you wanted to make. Where do we go now?
I do at some point have to deal relatively briefly with the respondent's notice. I'm just looking at the clock, it's about 12 minutes to.
Well, one point, perhaps this is the respondent's notice point, that's just not how I've classified it. The point is taken against you that even if you're right about section 29.6, that's still a less good remedy. It is in the sense specialist tribunal or county court, you've made that point, because they can use assessors and they are the designated tribunal for non-employment discrimination claims. But there's a different cross regime and possibly other differences which I can't remember, put my finger on. And I understand your fallback answer, or your primary answer to that is, well, if necessary, you would use Mar-leasing to take it out of Part 6 into Part 5. Is that the point you were about to come to? Or have I...
You wouldn't, that's not quite right.
Okay, no, I must have misunderstood.
It's close, but there are, I suppose, two big differences. The court still sits with two assessors, so it's not very differently constituted from an employment tribunal. There are two lay assessors.
Well, it doesn't, but it's not automatic. I think it's discretionary.
The default position is they will sit with two assessors. As in the tribunal, only in discrimination cases. In non-discrimination cases, of course, it's quite frequent now to have a chair sitting alone. But typically, there'll be assessors. That'll be the default position. There's, of course, what's different is, of course, the fees regime. One pays a fee to make a claim, and the costs regime, which may or may not be less favourable. It may actually be more favourable.
If you win.
Well, if you have a strong claim, what you don't want to do is go to an employment tribunal, unless it's very strong, in which case you may get your costs. Go to an employment tribunal, spend 12 days there, and you end up lighter in the pocket than you would have been, and there's no recourse unless some fairly strong facts have arisen. So it may be that the best solution for claimants is to have a choice. But we don't say it should be effectively Mar-leasinged into Part 5, but what we say is a jurisdiction provision. And we set that out in our skeleton. It's probably fastest to simply to show the court. It's at page 187 of our skeleton argument in the core bundle. That's paragraph 53 of our skeleton argument. So we say that if there's a breach of the principles of effectiveness and equivalence, because either there's a strongly dissuasive element in having to go to the county court, it's in effect impossible, or practically impossible, or too difficult, or the remedy is not sufficiently similar.
What's said against you is that in P, the court was very clear that the Mar-leasing construction was applied in order to implement EU law.
Yes.
And it's being suggested that your proposed wording would not be to implement EU law, but rather to allow your client to escape constructive liability. What's your answer to that?
Well, that's because they've gone through the wrong route. They start with P and end up here. We say we start by examining whether there's a Section 29 claim. And if the principles of effectiveness and or equivalence are breached by having to bring such a claim under Part 3 in a county court, then the jurisdiction provision in Section 120 is to be read in this way, which goes with the grain of the legislation, because it allows framework directive claims to be brought in an employment tribunal. So we don't say we bring it into Part 5 as such. We simply say, if one reads the section as including the words set out, which are very strongly borrowed from the adjusted Section 42 from P, to include the words in the jurisdiction provision, Section 29, 6 or 7, so far as a contravention falls within the scope of the framework directive by persons conducting a police misconduct hearing. Those would be cases in which the police officer's occupation has been interfered with and he's not been accorded equal treatment by the members of that tribunal. So there'll be framework directive claims brought against the panel as a public function, as performing a public function, but interfering with his occupation. And so reading the legislation conformably with the framework direction, we say for some of the same reasons as the claimant would say, if they're right about that, that the county court is not a sufficiently equivalent jurisdiction and procedure, one simply reads the section in this way so that these sorts of claims can be brought in the employment tribunal against the panel. Indeed, this would give the option to the officer of either the county court or the tribunal for those sorts of claims, because it wouldn't be turning his claim into a Part 5 claim, which would then engage the exclusion provision in Section 31. It would simply be adding to the scope of the jurisdiction of understanding the jurisdiction of the employment tribunal as including those sorts of claims arising out of occupation.
Yes, sorry. You said you were about to turn to the respondent's notice point. I couldn't remember which was the respondent's notice point. That, however, is not the point you were intending to turn to, was it, or was it?
No, my lord. I was just mindful of the time. It may well be I can save some time if I put a green pencil through some of my submissions over lunch.
Yes.
Rather than.
No, well, I'm afraid this is always how it goes. To some extent, you've been taken off course. You're asking nicely to rise a few minutes early. I think we're inclined to let you on the assumption that, which we will not be able to police, that may lead to some saving later. Right. Well, we'll sit again at 2.